Hello viewers, welcome to this lesson on Ombudsman systems in India. These will include the Central Vigilance Commissions, the Right to Information Act and the commissioners set up under this act, as well as the Lokpal and the Lokayuktas that have been set up by the state. One of the parameters indicated for good governance is accountability, including transparency in administration and freedom of information and expression that is required for the formulation of public policies, decision making, monitoring and evaluation of government performance. In consonance with these parameters, the Indian government has enacted several legislations to secure the freedom of information in terms of a Right to Information Act, accountability of the bureaucracy by the Central Vigilance Commissions Act. In addition to these, and following a long standing demand and campaign to secure political accountability, the Lokpal and the Lokayukta Act have also been passed. These legislations are in addition to penal statutes like the Prevention of Corruption Act 1988. The objectives of this lesson are to understand the various statutes that have been put in place to improve transparency and accountability in governance, to understand the mechanisms that these statutes have put in place to secure various goals, and to understand the important changes that these measures have brought about. The first of these statutes is the Central Vigilance Commission Act 2003. This law has been passed to facilitate an internal investigation by the state against offences alleged to have been committed under the Prevention of Corruption Act. The Act provides for the constitution of a Central Vigilance Commission which will inquire into allegations of corruption by certain categories of public servants of the central government. The Act only provides for an inquiry into the allegations and it does not prescribe the penalties if the allegations are found to be true. Thus, this is an act which is supplementary to the Prevention of Corruption Act and does not replace the penal provisions of the Prevention of Corruption Act. The Central Vigilance Commission consists of one chairperson and not more than 2 vigilance commissioners. The functions of the commission include the superintendence of the Delhi Special Police Establishment in so far as it relates to the investigation of offences alleged to have been committed under the Prevention of Corruption Act, or an offence with which a public servant who is specified in subsection 2 may, under the Code of Criminal Procedure, be charged with. The Commission may also investigate matters that are referred to it by the central government. The Commission, being an investigatory body distinct from a prosecuting body, has the power to regulate its own proceedings, and while conducting an inquiry, it shall have all the powers of a civil court to summon witnesses and receive evidence and other such matters. The proceeding before the Commission shall be deemed to be a judicial proceeding. However, after the inquiry, the disciplinary authority will take a decision on the investigation report of the Commission. The Commission does not have any adjudicatory role in terms of deciding whether the offence has actually been proved or not. The important role of the Vigilance Commission is to take note of certain allegations of corruption that are brought into light either by public servants themselves or members of public. Persons who are in government service and notice any illegal act that will fall within the purview of the Prevention of Corruption Act can bring it to the notice of the Vigilance Commissions. These persons are called whistleblowers, and the need for their protection has been noted by the Law Commission. The Law Commission has suggested that there needs to be a protection by law for those persons who are blowing the whistle, so to say, on acts of corruption within the department, and they are not waiting for members of public who are affected by these acts of corruption to bring it to the notice of any authority. The Law Commission has suggested a law called the Whistleblowers Act, which is also called the Public Interest Disclosure Protection Act. In certain cases which have raised a lot of public interest, for example, in the case relating to Mr. Satyendra Dubey, who was a graduate of one of the most prestigious institutions in India, had brought to light certain allegations of corruptions in the department that he was working in. He had written to the Prime Minister with regard to certain allegations, and he also noted that his identity was leaked and there was a danger to his life. Following his killing in Bihar, there was an increased need for a Whistleblowers Protection Act as well as for an authority that will investigate the allegations. The government in this case, at the instance of the Supreme Court, came forward with a notification under which they designated the Vigilance Commissioner as the authority to receive complaints about corruption and mismanagement in government. The Vigilance Commission has issued circulars which are available on its website, stating the manner in which complaints can be made to the Vigilance Commissioners confidentially, and as to how the name of the complainant will be kept secret and how the complainant will be protected from harm or victimization. On account of lack of sufficient publicity in this behalf, the number of complaints filed confidentially before the Vigilance Commissioner is almost negligible. The proper thing for any good government will be to enact the Whistleblowers Law on the basis of the draft bill provided by the Law Commission. Such laws, as mentioned above, coupled with the effective implementation of the Right to Information Act, will go a long way in ensuring that the government and the public sector operate without the malices of mismanagement, inefficiency or bribery. The second legislation closely following the Central Vigilance Commission Act is the Right to Information Act 2005. This legislation is an important piece of legislation that creates access to information regarding the functioning of the state. The Act gives effect to the fundamental right to freedom of speech and expression. This freedom of speech and expression is basic to a democratic country, and this freedom cannot be enjoyed if there is no dissemination of information. The freedom of press has been held to be a part of the freedom of expression, and this freedom will have to be read along with the right to information. The Supreme Court, in a series of cases starting from Bennett Coleman versus Union of India, has held the right to information as a part of the freedom of press, and in the case of S.P. Gupta versus Union of India, the Supreme Court has elaborated on how the right of the public to know about every public act and transaction is important to the democratic functioning of the state. These two cases have laid the foundation for the understanding of the right to information as a fundamental right. On the occasion of 10 years of the RTI, Aruna Roy, who led the Right to Information campaign, notes that a 40-day dharna in Bever in April 1996 led to the formation of the National Campaign for People's Right to Information. Set up with the twin objectives of drafting the law and supporting the use of RTI by citizens groups, a draft bill was circulated with the support of the Press Council of India in 1996. Following this initiative, state laws began to be enacted and continued to be in force until the national law was passed in 2005. The context of the Right to Information campaign was the context of the payment of minimum wages to workers in Rajasthan. Upon taking information from the state of the wages that were paid to persons and publicizing this information, it came to light that non-existent persons were paid wages by the state, and the persons who had actually worked on state programs were paid much less than what the accounts had shown. This information that was taken from the state created an awareness on how information can be an important tool in the hands of people, both to further their own rights, and in this case a basic right like the right to a minimum wage, as well as to expose the corruption that is inherent in government activity even at the village level. The Right to Information Act is one of the ways in which the operation of the Official Secrets Act 1923 can be curbed. Before the understanding of the right to information as a fundamental right, the Official Secrets Act could be invoked to deny information regarding many activities of the government. The S.P. Gupta case was a case in which information regarding the transfer of judges was held to be a part of the record of the government, which the government need not share with anybody under the Official Secrets Act. It was in this regard that the court observed that the public have a right to know about the actions of the government. The second Administrative Reforms Commission in 2005 also was of the opinion that the right to information was the key to better governance. It had also recommended that the Official Secrets Act be repealed. Although this has not happened, the RTI Act under section 8(2) of the RTI Act says that notwithstanding anything in the Official Secrets Act 1923 nor any of the exemptions permissible in accordance with subsection 8(1) of the RTI Act, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interests. Section 22 also provides for the overriding effect of the RTI Act over the Official Secrets Act and any other law or instrument having the force of law. This is the balance that needs to be struck between the Official Secrets Act and the RTI Act. Both legislations are to be read harmoniously towards the goal of public interest and improved governance. The RTI Act must not be read as an impediment to good governance, but as a tool to secure good governance. The Official Secrets Act must also be read in the context of the need for such a legislation and cannot be given too wide an interpretation. It must be restricted to cases of espionage, wrongful possession and communication of sensitive information detrimental to the security of the country. The preamble to the RTI Act refers to the need for transparency of information and the important role that an informed citizenry plays in establishing a democratic country. The preamble also refers to the need to balance the conflicting interest of state secrecy and public interest in receiving information. Under the Act, the right to information is defined in section 2J as a right to information accessible under the Act which is held by or under the control of any public authority and includes a right to inspection of work, documents, records, taking notes, extracts or certified copies of documents or records, taking separate samples of material, obtaining information in the form of diskettes, floppies, tapes, video cassettes or in any other electronic mode or through printouts where such information is stored in a computer or in any other device. Under the Act, public authority defined under section 2H means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, by any other law made by state legislature, by notification issued or order made by the appropriate government and includes any body owned, controlled or substantially financed, non-governmental organization substantially financed directly or indirectly by funds provided by the appropriate government. Section 4 of the Act makes it a duty of public authorities to maintain records for easy access and to publish within 120 days the name of the particular officers who should give the information and in regard to the framing of the rules, regulations, etc. Subsection 3 of section 4 states that for the performance of subsection 1, all information shall be disseminated widely and in such form and manner which is easily accessible to the public. Section 6 of the Act permits persons to obtain information in English or Hindi or in the official language of the area from which designated officers. The person need not give any reason for the request or any personal details. Section 7 requires the request to be disposed of within 30 days provided that where information sought for concerns of life or liberty of a person, the same shall be provided within 48 hours. Under section 7, subclause 7, before any decision is taken by an authority for the furnishing of information, the designated officers shall take into account the consideration or representation, if any, made by a third party as well. Section 8 provides for exemptions from the right to information. It provides that there will be no disclosure of information and certain information and content as stated in subclauses A to J thereof. Subclause B exempts information which is expressly forbidden by any court of law or tribunal or the dispute of which may constitute contempt of court. Subclause G exempts information the disclosure of which would endanger life, physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purpose. Subclause H exempts information which could impede the process of investigation or apprehension or prosecution of offenders. Subsection I exempts cabinet papers. There are other exemptions under the section. RTI Commissioners. The Act establishes a Central Information Commission as well as State Information Commissions. The powers of these commissions is to receive a complaint either when a person has been unable to submit a request as no public information officer, also known as the PIO, has been appointed, or the PIO has refused the request. There are other grounds mentioned in section 18 when the Commission may take up the matter. The Commission has the power to impose penalties when the information officer, without any reasonable cause, refuses to receive an application for information or has not furnished information within the time specified in the Act, or mala fideli denied the request for information, or knowingly gave incorrect, incomplete or misleading information, or destroyed information which was the subject of the request, or obstructed in any manner in the furnishing of information. The third legislation and the most recent legislation is the Lokpal and the Lokayukta Act 2013. The preamble of this Act states that it is an Act that would provide for the establishment of a Lokpal for the Union and a Lokayukta for states to inquire into allegations of corruption against public functionaries. India, having ratified the United Nations Convention Against Corruption and has a duty to enforce this convention, these bodies have been set up. This Act is a response of the government for a demand for a clean and responsive government and to provide an effective body to investigate, prosecute, contain and punish acts of corruption. The Lokpal shall consist of a chairperson and 8 other members, 4 of them shall be judicial members. The chairperson shall be a retired Chief Justice of the Supreme Court or a judge of the Supreme Court, or an eminent person of impeccable integrity and outstanding ability who has not less than 25 years of experience in matters relating to anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management. Neither the chairperson nor any member shall be a member of Parliament or a member of any legislative body of the state. It is fairly clear that a special effort has been made to keep this body separate from the executive and for the first time to appoint judicial members into a body that has been set up to contain corruption. Neither the CVC, which is the Central Vigilance Commission, nor the RTI has a mandate to appoint judicial members. This is a significant feature of the Lokpal Act. There is also an effort made to keep the body financially independent, unlike the 2 other bodies which are executive bodies, that is dependent on the executive for their finances. The Lokpal is intended to be financially independent by providing that the expenses of this body will be charged to the Consolidated Fund of India. The Act also specifies that the chairperson and members of the Commission shall not be eligible to be considered for certain positions in the government after their retirement from the Lokpal. In stark contrast to the earlier 2 legislations, which also deal with corruption in public offices, the Lokpal Act has both an inquiry wing and a prosecution wing. In an improvement over the CVC Act, the Director of Prosecution under this statute has the power to file a case before the special court and shall take all necessary steps to secure the prosecution of a public servant in relation to any offence under the Prevention of Corruption Act 1988. The Act under section 35 provides for the completion of trial within 2 years. One of the most important provisions of the Lokpal Act is section 23, which states that notwithstanding anything contained in section 197 of the Code of Criminal Procedure or section 6A of the Delhi Special Police Establishment Act or section 19 of the Prevention of Corruption Act, the Lokpal shall have the power to grant sanction for prosecution under clause A of subsection 7 of section 20. This provision has the effect of removing the requirement of sanction to prosecute any member of the bureaucracy except those who hold office under a constitutional provision and in respect of whom a provision has been provided, a provision for removal has been provided by the Constitution. Section 29 has provisions for a provisional attachment of properties of persons who are believed to be in receipt of proceeds of corruption and other persons. Section 35 provides for the setting up of special courts to hear and decide cases under this Act and the Prevention of Corruption Act. Lok Ayuktas may be formed at the state level and the state government is free to determine the scope and the jurisdiction of the Lok Ayukta. The Lokpal Amendment Bill 2016 makes the following addition, which is directed against proactive disclosures by public servants. Section 44 of the proposed amendment bill states that on and from the date of commencement of this Act, every public servant shall make a declaration of his assets and liabilities in such form and manner as may be prescribed. This is different from the original provision in the Act, which said that the public servant will be given time to make a disclosure of his assets. It is also important to know that several public officials, including judges of the High Courts and the Supreme Court, have made a proactive declaration of their assets and liabilities even before the Act directly applies to them. In fact, judges of the High Court and the Supreme Court are not covered by the Lokpal Act, in spite of which they have willingly made a proactive disclosure of their assets and liabilities. In conclusion, the enactment of the legislations discussed above has been the result of a constant public pressure to make government more accountable. The Lokpal bill particularly saw many public protests and demonstrations, and the Forum India Against Corruption had also drafted a Jan Lokpal bill. This is very significant because legislations are usually drafted by the state, but in this case the Jan Lokpal bill was drafted by members of parliament sitting with the members of the Forum India Against Corruption and drafting this bill. These laws are a result of a vigilant citizenry, and that vigilance must continue in order that these institutions deliver on the promise made. The functioning of the above enactments also depends upon making certain other legislations which are supplementary, such as the Judicial Standards and Accountability Bill, the Whistleblowers Protection Bill and the Grievance Redressal Bill. I hope you have enjoyed this lesson. Thank you.